Welcome to Ask the Lawyer radio podcast with attorney Brian Figueroa of the law firm Figueroa and Associates. This podcast features a recording of our most recent radio show aired weekly in New York City. We hope you enjoy the show, which features news, views, and interviews on matters such as immigration, personal injury, bankruptcy, divorce, family law, estate planning, wills and probate, deed transfers, civil rights, criminal defense, workers' compensation, and taxes, both individual and business. You can contact us at 855-768-8845 or visit us at www.askthelawyer.us. You have questions? We've got the answers.
Derivative U.S. citizenship. Before and after the Child Citizenship Act of 2000, derivative citizenship refers to the automatic acquisition of U.S. citizenship by a child through the naturalization of their parents, without the need for the child to undergo the naturalization process themselves. The legal framework governing derivative citizenship has evolved over time, with significant changes introduced by the Child Citizenship Act of 2000 (CCA), which became effective on February 27, 2001. This analysis explores the criteria for derivative citizenship before and after the CCA and outlines the documentation required to establish such status. Derivative citizenship before the Child Citizenship Act of 2000, legal framework, former INA 321. Prior to the CCA, the Immigration and Nationality Act, INA, provided for derivative citizenship primarily under Sections 320 and 321. Former INA 321 was the principal statute governing the automatic acquisition of citizenship by children born outside the United States to alien parents. Under INA 321, a child born outside the U.S. could derive citizenship through the naturalization of their parents, if specific conditions were met. Eligibility criteria under former INA 321. To qualify for derivative citizenship under former INA 321, the following conditions had to be satisfied before the child reached 18 years of age. 1. Parental naturalization. Both parents had to naturalize as U.S. citizens. However, exceptions existed. If one parent was deceased, the surviving parent's naturalization sufficed. If the parents were legally separated or divorced, the naturalizing parent had to have legal custody of the child. If the child was born out of wedlock and paternity was not established, the mother's naturalization was sufficient. 2. Child's age. The child had to be under 18 years of age at the time the parents naturalized. 3. Residency. The child had to reside in the United States as a lawful permanent resident, LPR. At the time of the parents' naturalization or thereafter begin to reside permanently in the U.S. while under the age of 18. It's important to note that under former INA 321, the requirement for both parents to naturalize was strict, with limited exceptions. This often posed challenges for children in single-parent households or where one parent was unwilling or unable to naturalize. Documentation required under former INA 321. Establishing derivative citizenship under former INA 321 required comprehensive documentation to prove eligibility. Proof of parents, naturalization certificates or U.S. passports of the parents. Child's birth certificate to establish the parent-child relationship. Legal custody documentation. Court orders or legal documents demonstrating that the naturalizing parent had legal custody of the child in cases of divorce or legal separation. Proof of lawful permanent residency, the child's permanent resident card, green card, or other evidence of LPR status. Evidence of residence in the U.S. Documents showing the child's physical presence and residence in the United States during the relevant period. Additional documents. In cases involving children born out of wedlock, evidence that paternity was not established by legitimation, such as affidavits or lack of paternity acknowledgement. Applicants seeking recognition of derivative citizenship under former INA 321 typically file Form N-600, Application for Certificate of Citizenship, with the U.S. Citizenship and Immigration Services, USCIS, providing the necessary supporting documents. Derivative citizenship after the Child Citizenship Act of 2000. Legal framework. Amended INA 320. The Child Citizenship Act of 2000 significantly simplified the process for children to acquire U.S. citizenship through their parents. The CCA amended INA 320, making it the sole provision for automatic acquisition of citizenship for children residing in the United States. The Act also repealed INA 321, thereby removing the previous requirement for both parents to naturalize. Eligibility criteria under amended INA 320. Under the amended INA 320, a child born outside the United States automatically acquires U.S. citizenship when all the following conditions are met on or after February 27, 2001. 1. Parents' citizenship. At least one parent is a U.S. citizen, either by birth or naturalization. 2. Child's age. The child is under 18 years of age. 3. Lawful permanent residency. The child is residing in the United States as a lawful permanent resident. 4. Legal and physical custody. The child is residing in the legal and physical custody of the U.S. citizen parent. Unlike the previous law, the amended INA 320 does not require both parents to be U.S. citizens or to have naturalized. This change has made it significantly easier for children in single-parent households or with one non-citizen parent to acquire U.S. citizenship. Documentation required under amended INA 320 to establish derivative citizenship. Under the amended INA 320, the following documentation is typically required: proof of parents' U.S. citizenship, U.S. passport, birth certificate, or naturalization certificate of the parent. Child's birth certificate, to confirm the parent-child relationship. Proof of lawful permanent residency, the child's permanent resident card, green card. Evidence of legal and physical custody, documents such as court orders, school records, or tax returns demonstrating that the child resides with the U.S. citizen parent. Proof of residence in the U.S., evidence showing the child's physical presence and residence in the United States. Applicants can file Form N-600, Application for Certificate of Citizenship, with USCIS to obtain official recognition of their derivative citizenship status. The form requires submission of the aforementioned documents to substantiate the claim. Comparative analysis. Before and after the CCA, the enactment of the Child Citizenship Act of 2000 marked a significant shift in the landscape of derivative citizenship. Key differences between the pre- and post-CCA frameworks include parental naturalization requirements. Former INA 321 required both parents to naturalize, with limited exceptions, whereas amended INA 320 requires only one parent to be a U.S. citizen. Custody considerations. The pre-CCA law necessitated legal custody in cases of divorce or separation, often complicating eligibility. Post-CCA, the focus is on the child residing in the legal and physical custody of the U.S. citizen parent, simplifying the process. Residency requirements. Both frameworks require the child to be a lawful permanent resident residing in the U.S., but the CTA provides clearer guidelines and broader applicability. Application process. While both require filing Form N-600 for official recognition, the documentation and eligibility criteria under the CCA are more straightforward, reducing the burden on applicants. Overall, the CCA has streamlined the process for children to acquire U.S. citizenship through their parents, reflecting a more inclusive and accessible approach. Conclusion. Understanding the evolution of derivative citizenship laws is crucial for individuals seeking to establish their U.S. citizenship status through parental naturalization. The Child Citizenship Act of 2000 has significantly simplified the criteria and process, making it more accessible for eligible children. Proper documentation remains essential in substantiating claims of derivative citizenship, and applicants are encouraged to consult with immigration professionals or USCIS resources to navigate the application process effectively.
Do you have a legal issue, question, or concern? Turn to Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us. You can also register for our paralegal program, get legal news, business consults, or other information on educational issues. Yes, ask the lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www